this is the last panel of today. And thank you for your patience. I can hear enthusiastic talks. I hope these talks continue after the panel in the form of questions. We have a wonderful panel of 5, all traveling from Spain, right? Yeah. And the floor is yours. So we will discuss the constitutional responses. And we are very quite excited to make it an interdisciplinary panel with your questions. Thank you.
Thank you very much.
Okay, well, thank you very much. Thank you all for attending this, well, as you said, kind of Spanish panel, I don't know. So you will hear 5 papers, all by members of the Jean Monnet Chair on European Constitutional Democracy at the University of Barcelona. You're actually, well, I think, focusing on this kind of constitutional problems in the context maybe also of the Catalonian referendum, Catalonian independence. So I'm very excited to hear more about that. So since we have 5 papers, we'll start and try to keep it, well, as short as possible. So we'll start with Daniel Fernandez, who is Assistant Professor of Constitutional Law at the University of Lleida. Oh, sorry. Okay. Well, the floor is yours, yeah.
Hello, everyone. Because we are Spanish, we start 5 minutes late. So 10 minutes late. Sorry about that. Before starting, I would like to express my gratitude, to have 2 apologizes, and also to make or explain the framework of my presentation. First of all, my gratitude to the European Center of Populism Studies for having us here with you today. So we are very pleased to be here. Second, to apologize. First, for my Soviet-style PowerPoint, so which cannot compete with the former PowerPoint. So I'm very embarrassed about that. And second, for my English, it's a little bit rusty, so have mercy on me. And also, I'm going to explain the framework of my presentation. My presentation pretends to be the base from which the other panelists will talk. So I will try to do the transition, more or less, from philosophy to political theory, and from political theory to constitutional theory, and they will try to finish off the corner in the other panels. So in order to do so, in my 15 minutes, maybe 16, I will try to answer 3 main questions in order to unveil part of the theoretical foundations of modern populism. The 3 main questions that I want to try to answer are the following. How do Heidegger, Lacan, and Gramsci influence the political theory of Ernesto Laclau and Chantal Mouffe? First question. Second one, what is the essential question that Laclau and Mouffe formulate, and what's their answer? And the third question, is there a common constitutional theory that underlies the implementation of the populist strategy? Let's gonna try to answer them one by one. Addressing the first one, it's true that Heidegger, that Lacan, that Gramsci are not the only scholars that influence Ernesto Laclau and Chantal Mouffe. Everybody knows that. But in my opinion, they have a special impact in their political theory in 3 main ways. The first influence is Martin Heidegger's Dasein. For Heidegger, human beings can only think about the world and think about themselves from a specific historical and social location, what he calls Dasein. And therefore, human beings cannot reason in a completely abstract way or make purely rational decisions. Ernesto Laclau and Chantal Mouffe accommodates this idea to political theory by stating more or less four things. There are no universal subjects in politics. There is no social omnicomprehensive ideology. There is no historical predefinite revolutionary subject. And also, there is no revolution that can eliminate social conflict forever. This is the first main influence on Heidegger and how Laclau and Mouffe take it and translate it to political theory. The second influence is Lacan's concept of constitutive lack. First, Lacan thinks that it's impossible to discover our full nature because there is a constitutive lack that prevents us from a full self-definition of ourselves. Then Lacan asserts that there is also a constitutive lack in language because it's full of empty signifiers whose meaning is made by discursive relations. And finally, Lacan says that society is also crossed by a structural or constitutive lack, because our collective identities are the product of a constant struggle to define and redefine empty signifiers through discourse. So, with this idea, Laclau and Chantal Mouffe transfer the idea of constitutive lack in human being, in language, and in society to political theory. And they end up stating more or less the following: that political identities have also a constitutive lack, which implies that we can construct and deconstruct them discursively by giving meaning to a plurality of empty signifiers that articulates them. So, for them, political identities are no longer permanent, and we can construct and deconstruct them through discourse. And the third main influence is Martin Heidegger's idea of politics as conflict and Gramsci's idea of hegemony. For Heidegger, politics is a conflict where, through discourse or through language, we can know which interpretation of social reality is true. And for Gramsci, hegemony is the ideological and cultural dominance that one social class exercises over the others, having its values and beliefs accepted as normal for the common society. With these third two ideas, first, Laclau embraces Heidegger's idea of politics as conflict, but denies the existence of an objective social reality, and also embrace the idea of Gramsci that we have to seek for hegemony. And he ends up stating something like this: politics is a permanent conflict that constructs and consolidates hegemony through discourse. That's the main objective of politics. So here, and for me it's the key point in Laclau, here for him, politics become completely independent from reality, from social reality. And then Chantal Mouffe, she takes the idea of politics as a constructed permanent conflict through discourse, but she goes a little bit farther. She says that pluralistic democracies are an unsolvable paradox, because although its institutions were created by liberalism to constrain the scope of political dispute, although it was created that way, with that idea, pluralistic democracies is where politics best unfolds as a permanent conflict. It's the only system where disagreement never disappears, because there is an adversary who holds antagonistic ideas but is recognized as a legitimate opponent. So, to sum up, we have three main influences, Heidegger, Lacan, and Gramsci, that leads them to four main ideas. No political universalities, political identities are constructed through discourse, politics is a permanent conflict to construct and consolidate hegemony through discourse, and the democratic paradox. This is the four main ideas. And with these four main ideas, we have answered, I think, I hope, the first main question. The second question, addressing the second question, what's the essential question that Laclau and Mo formulates? So for me, it's the following one, and it's in a specific book called Hegemony and Socialist Strategy. There we have the main question that leads to the answer. And the question is the following. How can political power be conquered and maintained within pluralistic democracies if universal problems no longer exist? If political identities are constructed discursively, and if any political conflict is permanently open? How we can win and maintain power with these pillars? The answer, we already know it. The answer for them is populism. But in my opinion, populism for them is neither a regime nor an ideology. It's just a strategy. A strategy to build a collective will within a pluralistic democracy where conflict is permanently open. And this strategy has three main steps. First step, it is necessary to discursively create an adversary. If we do not have hard political identities through which a historical enemy can be glimpsed, it is necessary to create them. Because in doing so, in creating our enemy, we can also create a collective movement against them. Second step, this adversary must be agonistic. Not just antagonistic, but also agonistic. Antagonistic is when something is opposite in beliefs, in how they behave, and how they see society. But when we mean agonistic, we think that we must believe that his electoral victory, the electoral victory of our adversary, leads us to be expelled from the public sphere. And here, in this second step, is when feelings gains momentum, not rationality. And the third step is, in order to not let them win, it's necessary to create hegemony. But in order to create hegemony, conflict must be constantly manifested in all spheres of life, to include new demands, to broaden the social base, and to update the gap between us and our agonistic adversary. So, with this main framework, we have the main question, we have the answer, and we have the strategy. And if we have this, we can go further and go to the third and last question. Is there a common constitutional theory to underlie the implementation of the populist strategy? As you can see, we have started with more or less philosophy, we go to political theory, and now we are going to constitutional theory. We are going to end up with constitutional theory in order to pass the panel to my colleagues. But the populist strategy differs depending on whether populism operates from the opposition or operates from the government. When populism operates from the opposition, it attempts to tense as much as possible the liberal democratic order. It seeks to maximize the space for dissent, to polarize citizens and relegate traditional institutions and intermediaries whose function is to reduce social conflict through consensus to a subordinate role. But when populism comes to power, the logic is the opposite. They seek to narrow down the permanent space for dissent offered by pluralistic democracies in order to prevent the creation of an alternative hegemony, but without formally eliminating the electoral process. But although we have two different ways to implement the populist strategy, I think we have three ideas that seems to be part of a common constitutional theory. And the three ideas are the following. They have, no matter you are in the opposition or in government, they have a common conception of popular sovereignty. For all of them, sovereignty can be present beyond the constituent moment. For them, people are unity, not diversity. And for them, people is not the equivalent to all citizens. So we change the former "we the people" for "we are the people." And this means that while they are in the opposition, they attempt to awaken these people through direct democracy against those who are taking away their sovereignty. But when they hold power, they think that the sovereignty is concentrated in the government. So they must eliminate institutional checks and balances to ensure that sovereignty has no limits. Second common constitutional idea that they have. They don't want political representation. They want leaders. Because for them, leaders no longer represents, but rather embodies a movement that seeks to seize the power or maintain it united against the attack from the opposition. Hence, whether they are in the opposition or in the government, they make efforts, all of them, to strip away parliamentary powers and transfer it directly to the people or transfer it directly to the government, depending on one's political position they are. And the third and the last common constitutional theory or idea is that for them, democracy is decision, no longer discussion or consensus. This means that dissolves the duality between constituent power and constituted powers. It means also that liberal constitutions are perceived as a straitjacket that oppress the free development of sovereign will. And it means that they are always trying to remove all possible obstacles to the exercise of the sovereignty power. Once we have answered the three questions, I would like to conclude recapitulating and making three slide conclusions, and I would like to end with a doubt made more or less as a question. The three main conclusions are the following. The reconfiguration of the way that Heidegger, Lacan, and Gramsci conceive the human nature, conceive language, and conceive politics allows Laclau and Mauve to create modern populism. Second conclusion. Populism was conceived as a strategy to conquer and maintain power in pluralistic democracies in the 21st century. This is why their theorists never considered the issue from a constitutional point of view. So we do not have a theory of populism constitutionalism. We do not have any fundamental book of this kind. We cannot go to the library and have, oh, this is the main book that you have to read. But, and this is the third conclusion, however, the implementation of populism has led to various conflicts with classic constitutionalism. And the joint studies of these conflicts has revealed a common constitutional theory that revolves around the three main ideas: the sovereignty of the people as an expelling unity, leadership, not political representation, and the third one, democratic decision. And it means that all of them, they try to erode constitutional democracies in very possible way. And I would like to finish, as I said before, with a question. Can a democracy survive when political confrontation is constantly reproduced in all spheres of social reality? Or going a little bit further, won't a political system that is permanently under tension generates social discontent that ultimately leads to the acceptance of undemocratic solutions? Thank you very much. I'm at your disposal.
Thank you very much for holding your time, Kenneth. We will now listen to Marco Antonio Simonelli, who is Assistant Professor of Constitutional Law at the University of Barcelona, and we'll be talking about the independence of the judiciary and its erosion. Yeah. So also for like 15 minutes, if possible.
So good afternoon. Thank you, first of all, to the European Center of Populist Studies for the invitation to Sumaya. Okay, now I see, for being the face and the person who had to organize all this. And now I am afraid I'm going to be a little bit more boring than Daniel before me, because my presentation will be the first one to be strictly legal. And more specifically, what I'm going to do is to try to clarify how in the last 2 decades the role of judges in constitutional democracy has become an increasingly debatable issue, and how, as a consequence of this challenge to the role of judges in constitutional democracy, we have assisted to attacks on judicial independence. Before doing that, of course, I think it may be necessary, unfortunately, to clarify what judicial independence means, and before that, also to clarify, to explain, or at least to make the case for an independent judiciary in constitutional democracy, which is also, this is becoming increasingly debated. So, if we start with the first question, why do we need an independent judiciary? In classic liberal constitutionalism, the idea of an independent judiciary is famously attributed to Charles-Louis Secondiat, le Baron de Montesquieu, who in 1748, in his famous L'Esprit de Loi, elaborated a theory of separation of powers, saying if we want the government to be limited, if we want to be sure that power is not abused, then we need to separate the power. How we separate the power into three: government, legislative, and the judiciary. That is the main innovation of Montesquieu as to the separation of power. But if we read Montesquieu's words, in the end, he was more worried about the limiting judiciary. Montesquieu was famous for having said, judges need to be la bouche de la loi, the mouth of the law. We need to limit judicial discretion because we don't want the role of judges to be expanded in the functioning of a democratic state. Conversely, if we cross the ocean and we go to the United States, we found that in one of the founding texts of modern constitutionalism, that are the Federalist Papers, Alexander Hamilton, that was writing under the name of Publius, was conscient of the perils faced by the judiciary, because he thought that the judiciary was the weakest of the three departments of power. it does not have, sorry, once again, neither the power of a purse belonging to the parliament, neither the power of a sword belonging to the government. So it's kind of without defense against these other two powers. And so Alexander Hamilton argued, in the end he was successful with this argument, in putting in Article 3 of the US Constitution, the tenure during good behavior of federal judges, as well as the protection of salary of judges. And in the US tradition, and this is also a big difference with the original European tradition, since the very outset, judges were also called to play a role in the separation of power. If we look already to the historical judgment of US Supreme Court in Marbury versus Madison, 1803, judges were started to play a role in the separation of power, delimiting the competencies of the executive and the legislative. Also, whereas in the European tradition, the judiciary is traditionally considered as a guarantee of fundamental rights of individuals rather than the separation of power. So, having clarified, I hope at least, why we need an independent judiciary, maybe it's time to clarify what is an independent judiciary, what makes a judiciary independent. Where there are many possible definitions of judicial independence. I think this one is pretty complete. I'm not going to read fully because for the sake of time, but essentially you have all those guarantees that makes an independent judiciary. Security of tenure, decent salary, incentive for promotion, a system of prerequisites and rules of jurisdiction that are not easily amendable by the legislative and the executive. Now, moving, what is lacking in this definition is probably one issue, that is a system of appointment whose impact on judicial independence is debated amongst constitutional scholars. We have essentially two models here. One is the European one, career judges, selected through a public competition organized most often by the same judiciary, or politically appointed judges. US model, once again, as well as all Latin American countries that have followed this model. As I said, the system of appointment impacts on the relationship of the judiciary with the other branches of power, but whether it has an impact on judicial independence is at least questionable. So, trying to link all this with populism. Why judicial independence is under attack? First, critics of judicial independence, or at least of the role of judges in a democracy, are to be found in the North American constitutional scholarship. Already during the 80s, so well before discussions around the populism, there were very prominent scholars, such as Alexander Bickel, discussing and criticizing the US Supreme Court for an excessive role in shaping American democracy. Then we are at the beginning of this century. Another Canadian scholar, Ran Hirsch, published a book that you see the front page here, called Towards Juristocracy, saying directly, the power of judges in constitutional democracy is becoming so huge that we are no more in a democracy. We are living in a juristocracy. Of course, these doctrinal critics were not translated at the very beginning into direct attacks on judicial independence. If we we go back to Europe, we see that for those attacks to be visible, we have to wait for the rise of populism. Well, here you have, of course, Viktor Orbán, Prime Minister of Hungary, who rose to power in 2011, and probably Hungary was the first European country to experience a direct attack on independence of its judiciary, an attack that was watched hopelessly by the European Union institution and other member states. But why we do consider that populism is radically incompatible with judicial independence? This morning, most of panelists have said that populism is a teen ideology. There is no ideological content into populism, and I think we can all agree on that. But from the perspective of constitutional law, it is also unquestionable, or at least there is an unanimity among scholars of the fact that one of the central tenets of populism is the fact that the will of people, as expressed by its leaders, charismatic leaders, cannot be constrained, cannot be subjected to the Constitution or to the bodies that are called to enforce the Constitution, judiciary, constitutional courts. And so if we consider that constitutional democracy is based on the idea that elected majority are subjected to the Constitution, you can see that this incompatibility is almost absolute. How judicial independence concretely is attacked by populist majorities? I mean, I'm talking about populist majorities, ruling majorities, Hungary and at least until 2024, Poland, because only when only government and parliament majorities have the possibility to formally attack judicial independence, for instance, by lowering the mandatory retirement of judges, so pushing out judges appointed under previous democratic regimes, creating disciplinary courts or attributing disciplinary powers to the Minister of Justice, court packing, or this very classic populist playbook of attack on judicial independence. Probably it can be more interesting to look at informal attacks on judicial independence, because it has been written a lot about formal attacks, this measure, but there are more subtle ways to impinge upon judicial independence that are affecting also consolidated Western democracy. Here I put a list on some statements of the last 6 months or so from Musk, from Nigel Farage, or Donald Trump. All are attacking either judicial decision, either personally judges, either the judiciary as a whole. So there are different scale of gravity. Maybe in the world of Musk you can find an echo of Ranil's word. I doubt that Musk actually read the word from Ranil's, but still, tyranny of the judiciary, juristocracy can be considered a synonym. And of course, those attacks in the end impinge, undermine the legitimacy of the judiciary and its capacity to hold accountable political powers. Here you have a passage from an open letter that written by the governments of Italy and Denmark, amongst others, directed at the European Court of Human Rights, in which there is a direct challenge to the scrutiny of European Court of Human Rights on the expulsion politics of national states. I decided to put you here this example because I think you can find here what is the paradigmatic example of populist ideology. The majority of this society, they say, the president of the government, is against the strong role of the European Court of Human Rights in protecting the rights of aliens in Europe. But moving to another form of attacks on judicial independence, I think we can mention polarization, the polarization of society. This is a phenomenon that is pretty much visible in all Western society, at least, and how growing polarization of society is affecting judicial independence. This effect is visible first and foremost on judicial appointments. So we have to move to the US, where there is a political appointment system. And I think the US makes a paradigmatic case of what I'm trying to argue, because if you consider the history of appointment to the Supreme Court, you will see that what was once a highly respected jurisdiction domestically and abroad is being transformed into a partisan court. How? First, we have to go back to 2013, to the second term of Obama presidency. Obama was not capable of appointing federal judges because of a strong minority of Republican in the Senate, and for the appointment of all federal judges, the US Constitution established a 2/3 majority of the Senate. So Obama decided to activate, and the Democratic majority of the Senate decided to activate the so-called nuclear option, allowing the Senate to appoint federal judges by a simple majority. This rule then in 2017 was used, this time for the Republican-controlled Senate, to appoint a judge of the of the US Supreme Court. And all the last appointments since 2016 until now have been made with simple majorities. The effects are clearly visible on the independence, or the perceived independence of the US Supreme Court. In 2024, only 30% of Americans considered the US Supreme Court to be independent, whereas this percentage in 2017 was 40%. So there is a sharp decline in the public trust in the US Supreme Court. And this decline in public trust is affecting as well, of course, the capacity of US Supreme Court to account the government and the parliament. How much? 5 minutes.
5 minutes.
Perfect. No, I'm happy about that. So situation in Europe is not that different. Here you have the Eurobarometer of 2025, showing that, especially in southern European countries, amongst others, Italy and Spain, less than 40% of the population consider the judiciary to be independent. And this is creating problem as to, once again, the capacity of the judges to hold the government and the parliament accountable for their actions. So this is a rather dark picture I try to make of the status of judicial independence in Europe and in the US mainly. But if we look at the last 10 years, much has been learned. Populism, especially in Europe, is an issue at least since 2011, and the European states have started to adopt measures to fight to protect judicial independence against the populist side. Here I indicate some of the possible remedies of different kind that can be put in place to defend and strengthen judicial independence. First is probably increasing the complexity of judicial appointment procedure. By increasing complexity, I mean, first of all, enhancing the number of actors involved in the appointment of judges. Experience shows rather clearly that when is only one body, normally it's the parliament, to appoint all the members of a judicial body, such as in the case of the Polish Constitutional Tribunal, it is easier for this body to be politically captured. Whereas if we divide the appointment competence between different state bodies, it will be harder for a single majority to appoint or politically capture the member of this body. Second remedy that can be put in place, anti-gridlock mechanism. One of the problems with judicial independence in Europe as well and the US has been the fact that the polarization, which I was mentioning before, is making harder to reach a compromise amongst political forces in the identification of suitable candidates for judicial position. This is the case of Spain, where the appointment to the Judicial Council had been blocked for 6 years for the incapacity of the two main political forces in parliament to find an agreement as to the new composition of a Judicial Council. And there have been put in place legislative measure in some European countries. I'm thinking about Germany. In December 2024, Germany implemented a reform of the law of the Constitutional Tribunal, establishing rules to be followed in case either the Bundestag or the Bundesrat, which are the two bodies appointing the judges to the Constitutional Tribunal, cannot reach the two-thirds majority for the elections of federal judges. Third remedy, increasing the transparency and the openness of judicial procedure. This is probably one of the most effective ways because this can be done by the judiciary alone. The example here is the Italian Constitutional Court, I believe. The Italian Constitutional Court in the last 5 years put a lot of effort into opening up its traditionally closed procedure. In 2023, the procedure was opened up for the submission of amici curiae, something that was prohibited under the previous procedural rules of Italian Constitutional Court, but also the Italian Constitutional Court tried to be closer to the citizenship. Constitutional judges are visiting in the framework of a program that is called La Corte nelle Carceri, is visiting prisons, is visiting public schools, explain what it's doing. And as a result, the Italian Constitutional Court, together with the President of the Republic, is amongst the most respected public institutions in Italy. And then I would like to close with a remark. Our project is a European project, so we have to defend the European Union, or at least argue that it's something good for the European people, the role of multi-level governance. And I think here we have to consider Poland. In the Polish case, the European Union institution, first of all Commission, then the Court of Justice, were capable of acting timely and in a strong manner to defend the independence of the Polish judiciary. And in the end, I think it was a major factor in avoiding outright collapse of judicial independence in Poland. And if we consider probably the most problematic case in Europe, that is the case of Hungary. Also in the case of Hungary, one may argue that the role of the European Union was fundamental in preventing the descent of the Hungarian state into authoritarianism. I think the example is pretty visible to everyone. Last week, the Gay Pride celebrated in Budapest wouldn't have been possible if Hungary was not a European Union member state. I close here. I hope I did not overstep my time. Thank you for the attention.
Great. Thank you very much. So now it's Elia Marsal's turn. Oh, no, sorry.
Yeah.
Well, it's like that on the list, but you want, or do you want to go? Or what
I mean, I don't mind. Whatever.
Okay, so we will be listening to Nuria Gonzalez, right? And her paper, Pro-Independence Movements as a Populist Way Out in Multinational Contemporary Societies, for 15 minutes as well. We'll be a little bit short on time, so it would be good if we try to...
I can keep it short.
Yeah, great. Thank you very much.
Thank you very much. Good afternoon to everyone. And of course, also a huge thank you to the European Center for Populism Studies and also to Meije for organizing this. Thanks a lot for having us here. And this afternoon, I would like to explore the relationship between pro-independence movements in liberal constitutional democracies and populism. And in order to do that, I will bring up two cases, the Catalan, 2017, and the Scottish case in 2014. So Marco was already mentioning that. This morning we said that populism might be a too ambivalent term, too diffuse, but it's true that for constitutional lawyers, at least when we speak in institutional terms, it's very clear that a populist leader is the one who disdains the law and institutions, very particularly counter-majoritarian institutions, the courts, and also constitutional courts, or the judiciary, the ordinary courts, and constitutional courts. And this is exactly what we are going to see when exploring some of the characteristics and some of the features of the Catalan pro-independence movement. And this is something that we are not going to see when exploring the different response of the Scottish leaders when the law and the courts told them that they could not do something they were aimed to do. So starting with the Catalan case. I mean, I have a presentation, but just forget it because I think I'm not going to follow it very strictly. Since 2012, the Catalan government tried to organize an independence, a secession referendum in Catalonia. And Catalan leaders tried to convince the Catalan population that this was an excellent idea. Widely used slogans those years said, this is about democracy, or voting is normal in a normal country. But actually, Organizing an independence referendum is not as common as one might think. It's not so common to vote on the dismemberment of your country. It has occurred in Canada twice, in Quebec. It has also occurred in this country, but it has been banned. It has not been permitted in the US, in Germany, in Italy, and also in Spain. So it's not so normal, and maybe if I have time, I also might say something more about this, about the relationship between secession and democracy. But let's try to focus now more specifically on the populist characteristics. So in Spain, basically, there are two problems for the organization of a referendum on independence. The first one is the lack of political will, and the second one is constitutional, or if you want, legal impediments. As for the lack of political will, well, the organization of a referendum on independence means recognizing that that people that is entitled to vote and to decide is sovereign. It enjoys a national character and is sovereign. For many people in Spain, this represents a threat to the sovereignty and to the national character of Spain as a whole. And this is why, at least for all these years, the main Spanish political forces have opposed to the organization of such a referendum. So no political will. But apart from the lack of political will, there are also constitutional impediments. Our constitution, in 2 articles, basically says national sovereignty belongs to the Spanish people. And then it says the constitution is based on the indissoluble unity of the Spanish nation, the common and indivisible homeland of all Spaniards. So sovereignty is reserved for the Spanish people as a whole. The Spanish Constitutional Court has stated in several occasions that advocating or promoting secession, of course, is permitted, is a legitimate political aspiration. But if you really want to implement that by firstly organizing a referendum, you need first to amend, to modify the Spanish Constitution following a certain amendment procedure. True. Amending the Spanish Constitution is very difficult. It requires qualified majority, so it requires a huge consensus. So it's almost impossible. Despite the clarity of the Spanish Constitutional Court and also the highest court of Catalonia, the Catalan government in 2017 decided to submit 2 laws to the Catalan parliament that were approved. Laws that were aimed at the organization of the referendum and then at the creation of an independent republic. What type of majority did support those laws? It's true that there was an absolute majority in the Catalan parliament, 72 seats out of 135. But we also have to bear in mind that those 72 seats represented 48% of the Catalan electorate. I'm saying that in order to convey the idea that Catalonia is a divided society when it comes to secession. There was no clear majority in favor of secession within the Catalan parliament. Both laws, ordinary Catalan laws, were against the Spanish Constitution, as we have seen, but also against the Catalan Statute of Autonomy, right? And funny, in order to, for instance, amend the Catalan Statute of Autonomy, it is required a majority of at least 2/3 in the Catalan parliament. So again, a huge, a very broad majority, because constitutions or the statutes of autonomy are the rules of the game, and we want to make sure that there is a huge consensus when we change the rules of the game. These ordinary laws were approved in the Catalan parliament, as I said, with an absolute majority, but not a more qualified majority, and the referendum took place in October 2017. You might remember that. Well, this is an example of political leaders. Going to skip that, and this as well. This is an example of political leaders who decided to go ahead, to move forward, despite there were clear messages from the courts. Now we are going to see which was the reaction of the Scottish leaders when the courts said something they did not like. So you know that in 2014, Scotland organized a referendum, and in fact, within the Western Wall is the last legal secession referendum that has been organized. In Scotland, there was no problem of lack of political will, there was no problem of constitutional impediments. As for the political will, it's very interesting because even those political leaders who oppose the devolution process in the UK in the 80s, famously Margaret Thatcher, they were at the same time convinced that if the Scots wanted to depart from the United Kingdom, they had the right to do that. Here is a quotation from the memoirs of Thatcher saying, well, the Scots have an undoubted right to national self-determination. So it might be Scottish history before the Union at the beginning of the 18th century. It might be pragmatic economic reasons. The laws of Scotland would not have the same impact in the UK as the laws of Catalonia, that represents around 20% of Spanish GDP. It might be centuries also of uninterrupted tradition of parliamentarism and tolerance within British politics. But what is evident is that there was no problem at that moment within British politicians to accept that. I mean, what the British government after 2000, after the Scottish election of 2011, debated in Westminster the possibility of an agreement with the Scottish government. The debate lasted more or less an hour. And no MP opposed to the idea of the organization of the referendum because they assume and they admitted very clearly that, well, the SNP had been campaigning very clearly in favor of independence. They had obtained for the first time an absolute majority in the 2011 election, so there was no reason why they shouldn't organize a referendum. But it's, I mean, it's, and particularly for lawyers, we also have to understand that in the case of the UK, unlike in Spain or unlike in Italy or unlike in Germany or in the US, there are no constitutional impediments because your constitutional law is very flexible. You don't have such a rigid written text. You of course have norms that can be considered constitutional and that are written, but you also have other types of non-written norms that are accepted by the parliament and by the courts as constitutional. So this gives the system a lot of flexibility. And additionally, very famously, very contested, but you also have this doctrine of parliamentary sovereignty where the parliament can enact and can amend any type of law. There is no supreme law that has to be respected at all time unless the parliament has restricted itself before to do that. So, it is, however, true, and this is important to the last comment, and it's true that the Scotland Act reserves certain issues to Westminster. So there are issues that cannot be decided by Scotland. And among these issues, the Union and the Constitution. So at that moment, it seemed pretty clear that Scotland could not unilaterally organize a referendum on secession, but Westminster had to organize that. But it was done. 2013, Westminster decided to amend, on a temporary basis, but to amend the Scotland Act in order to permit the Scottish government to organize the referendum on secession. Okay, what happened later on? After the consolidation of Brexit in 2022, Nicola Sturgeon asked, or very clearly, in fact, right after Brexit, but it was only a few years later, once it was clear that Brexit was a real thing and a serious one, Nicola Sturgeon said, look, we want to organize a second referendum because the EU membership was a fundamental issue. Right, yeah, I'm going to finish.
Actually, 3 minutes.
Yeah, sure. I'm going to finish very, very quickly. So she said, we need to organize a second one because EU membership was a crucial issue for us. But she was very aware that Scotland could not do that unilaterally. But she said, well, in fact, we are drafting a bill that aims at organizing a consultative, an advisory referendum. And therefore, since it will not have legal effects, it's not going to be a self-executing referendum, because if it's not only an advisory referendum, it's within the competence of Scotland. But in order to be sure that I'm allowed to do that, that the law permits me to do that, I'm going to ask the UK Supreme Court if I'm really allowed to do that. I think I am, but I want to be sure. And the UK Supreme Court, November 2022, said, no, you are not allowed to do that. I mean, an advisory referendum in a democracy like the UK has huge effects, maybe not legal effects, but of course it's going to have a huge effect in a democracy like ours. It will have an impact. So it's not so different, an advisory referendum, than a referendum that is also self-executing. Well, the Brexit referendum, in principle, was also an advisory one. But of course, in a democracy like the UK, if the people speaks, well, politicians tend to follow. So the UK Supreme Court sent a very, sent a very disappointing message to the Scottish government, which was the response of the Scottish government, unlike the response of the Catalan government, said, okay, we don't like this response, we don't like the position of the court, but we are going to obey the court, we are not going to organize a referendum. We will try to use future elections as pseudo-referendums, but at the moment we are going to convey with the law. Last sentence. I think that one of the differences between Catalonia and Scotland, and one of the reasons Catalonia is probably today a much polarized society with more wounds than Scotland, is because our leaders decided to follow a populist way instead of trying to convey with democratic institutions. Thank you very much.
Great, thank you very much. So now it's your turn. Great. Elia Martal will be presenting a paper on referenda as a biased and populist tool. Great. So also 15 minutes.
Thank you so much. First of all, I also would like to express my gratitude for the invitation, for the organization of the Congress. Secondly, two apologies. First of all, the title, which is in the program, is not my title. Sorry, I should have warned you, but I completely forgot about it. I changed it somehow, but it's not reflected. So the title is...
Is that the title of the paper, or because I have it, so I can give it?
Okay, very good.
That's the role of parliaments in secession referendums.
Is there, sorry?
The role of parliaments.
Yeah, sorry. I didn't
Exactly, that's what I have. So the role of parliaments in secession referendums. Canadian doctrine.
Canadian doctrine, exactly. Yes. And consensus democracy in designing decision-making process. Second apology is that I also thought I had downloaded my presentation, but I don't know, it's not there. So I'm going to do it without the PowerPoint. Maybe I'm very little fond of technology, so maybe I feel more comfortable without the power presentation. Anyway, as the chair of the panel has already said, I'm talking about the role of parliaments in secession referendums, and I'm trying to link this with the doctrine set up by the Supreme Court of Canada that is used in order to develop a procedure in order to make decisions in very sensitive issues. So my work is something I've just finished, and is a work that takes as a starting point the literature existing about secession referendums and the fact that secessionist theories and secessionist movements regard Canada and the United Kingdom as examples of liberal democracies that have managed to overcome the traditional resistances when dealing with referendum secessions, and they have accepted to use secession referendums in order to manage territorial conflict. According to these theories, according to this movement, this would somehow demonstrate that it is possible to overcome this traditional resistance, and that moreover, somehow a new paradigm in relation to secession would have raised from the very central and important opinion given by the Canada Supreme Court in 1988, or at least new, or at least the possibility that to challenge the traditional vision of this. However, my work also starts from a more specific observation. And this observation has to do with the fact that if we look closer to the opinion given in 1998 by the Supreme Court, we can see that the referendum does not occupy the center of the reasoning of the court, but it is rather the parliament that is at the center of this opinion, of the reasoning. This is something, the parliament is something that is also at the center of the federal act, the Clarity Act, that is passed by the parliament in Canada in 2000, just 2 years after the opinion given by the Supreme Court. And this is something that is later echoed, as has just been explained by Nuria González, in the United Kingdom, in the 2022 opinion given by the Supreme Court in the United Kingdom in relation to to the possibility of passing Scotland a new, celebrating a new referendum. This centrality of the referendum is something that is also to be observed more recently in some provinces in Canada. And I am referring to this, to Alberta's initiative. Alberta has passed an act in 2022 that is called Alberta's Sovereignty Act, which allows the possibility of the provincial parliament to suspend a federal act that may be interfering in Alberta's competence or may be harming the interest of the state, of the province, so to say. And this is something to be seen also now in Quebec, where debate is taking now place regarding the possibility of passing a constitution in Quebec or of passing an act like the one in Alberta that may allow the state of Quebec, the province of Quebec, to stop any legislation of the federal institutions to be applied in Quebec when it affects its specificity, its identity. So what I try to do in this work is to analyze the role which is actually given to the parliament in all this reasoning, in all these texts that support the doctrine that has been set up by Canada's Supreme Court, and to weight its importance, the importance of the parliament in comparison, in balance with other institutions. By doing this, I analyze, of course, the 1998 Supreme Court opinion, but I also analyze the opinion given in 2022 by the UK Supreme Court, and also the Clarity Act passed in 2 years later, the Supreme Court's opinion in the Canadian Parliament, and also these provincial initiatives. More specifically, the aim of my work is to move beyond the referendum issues and to delve in more in other aspects that may be central for the articulation of democratic constitutionalism. For instance, first of all, I try to analyze one very important aspect of the doctrine set up by the Supreme Court in 1998, which is the explicit recognition that there are limits inherent in constitutional systems, within constitutional systems, when dealing with territorial conflicts. And these limits, these problems are particularly evident in countries that are called heterogeneous states, such as, which is a topic that we have talked about previously this morning. These are states that have structural minorities, permanent minorities. And this is something that is the point of departure in the reasoning of the Supreme Court in 1998. Second aspect I want to delve in is the type of solution that is given by the court to this problem, to the conflict that underlines this opinion, the conflict between legality and legitimacy, or the conflict between rule of law and democracy. The court, far from reducing the solution to celebrating referendum inside the territory where there is a claim for secession, such as Quebec, the Supreme Court, what it does is to demand a procedure, a highly complex procedure, that tries to articulate the very different interests at stake. So it would be a procedure that where the interests of the majority are represented, the interests of the minority are also represented, and also the interest of the minorities of the minorities. And all these interests, different interests are represented through different type of institutions. Federal institutions on the one hand, Quebec's institutions also, the institutions of other provinces, and organizations, such as indigenous people, would all be represented by a variety of mechanisms, such as referendum, but referendum would be only one of that, or different stages in the adoption of the decision. In all these different stages, the parliament has the central role. So the parliament is the arbiter in the process. It also guarantees that the different actors intervening in the procedure act according to the procedures laid down by the law, and makes important decision-making functions when dealing with the reform of the Constitution that, according to the court, has necessarily to take place. The aim of my paper, the aim of my research, is to point out, to reflect upon the type of interpretive framework that the court may be using. And what I try to convey is the idea that the court is trying to design a procedure through which, if not an efficient response can be reached, at least one that may be perceived as legitimate. That is, a procedure that is coherent with a democratic theory of a constitutional state. This is what the court may ultimately be trying to do, and when doing so, you could think that the court is somehow connecting with those social sciences disciplines that are preoccupied, are concerned with the problems inherent to decision-making processes. That is, on the one hand, we could consider that the court is connecting with social choice, and on the other hand, with public choice. What is social choice? It could be defined as a theory that analyzes the logical limits that exist in any procedure that has to aggregate individual preferences in a collective decision. So social choice would point to the type of problems that mechanisms such as referendum pose when making decisions. On the other hand, the court may also be connecting to the type of preoccupations that have given rise to a discipline that is called public choice, which is concerned with the limits existing in public decision-making. Not any type of decisions made, such as social choice, but public decisions. Public choice, like choice theories, which are the theories that are used by defenders of secession, public choice considers that political obligations have to be grounded on a consent. And public choice thus defends the idea that consent is as important in private law as in public law. Not only in private law, where individuals make their own decisions in their private lives, but also in public law, where we are used that public powers make decisions for all of us. Public choice says, also in the field of public choice, it is important that we give our consent to political obligations. But in contrast to choice theories, public choice argues that in very divisive, very controversial decisions, it is very difficult to make it work, to reach a consensus and to apply majority rule. So for public choice, and this is what I think may be inspiring, okay, I'm going to finish, what may be inspiring the reasoning of the court, the more divisive and more controversial a decision is, the more complex the procedure has to be. And secondly, there is no general will which is independent from decision-making procedure. So public choice somehow rejects an organic conception of democracy, saying there is no will independent of that procedure. So two conclusions in my work which somehow connect with this last idea. First of all, in this doctrine set up by the Canadian Supreme Court, there is an explicit recognition between the connection, explicit recognition of the connection between, on the one hand, the legitimacy of the decision made and the costs inherent to the procedure. These costs are greater, the bigger, the more controversial the decision is. And secondly, the court may also implicitly be claiming that there is a need to nuance, a need to make more complex the idea of a people, the idea of a general will, and that we have, in certain contexts, such as the ones dealing with secession or any divisive question, we have to complement majoritarian democracy with consensus democracy, that is representative, pluralistic, and deliberative democracy. Thank you for your attention.
Thank you very much. The last paper on this panel is the last panelist, sorry, on this panel is Roger Bouda, who is assistant professor of constitutional law at the University of Barcelona, and he will be presenting a paper on potential solutions.
I'll see.
Potential solutions, maybe. Second chambers, demos and majoritarian body. So,
Thank you. Good afternoon, ladies and gentlemen. It is such a pleasure to be here at the University of Oxford. My gratitude to the ECPS for their kind invitation and their efficient organization. May I offer a word of caution before I get started. So the initial idea when we submitted our proposal was to talk about potential solutions, second chambers, demos, and the majoritarian body. Now this was maybe too generic. As the months have passed, I decided to focus that on a specific case, which is the case of the Spanish Senate. So while this may sound potentially maybe too parochial a subject, too Spanish a subject, I think one may draw conclusions from the Spanish experience that may be applicable to other countries that have second chambers or bicameral systems. So of course, bicameralism, having a Senate, usually is a consequence of the, shall we say, anti-populist assumption that the demos may be simply represented as a united sort of body in one single chamber based upon the principle of one man, one vote. By introducing a second chamber, we assume that the demos is not such a simple reality, and that then we might need a second chamber to represent in some way or another the plurality, the complexity of a given society. Now, in Spain, during the constitutional process between 1977 and 1978, there was a bit of a debate over what sort of a second chamber Spain should have. And basically the debate involved two different models. The first model was that of a territorial chamber, which followed mostly the classical federal second chamber, inspired remotely by the US Senate, meaning a chamber that either mostly occupies itself with regional regional matters, with matters involving the territorial organization of the state, or alternatively, a territorial chamber that seeks to provide, shall we say, a forum or a mechanism through which the regions, the members of the federation, the states, depending on the country, may participate in the decision-making process at the national level. That was one option. The second option was, of course, the more classical model of the moderating/revising chamber, which basically is remotely inspired by the British system, by the British House of Lords, which does not have, at least not obviously, this territorial dimension, and which instead seeks to provide an element of moderation, of sober reflection in the parliamentary system. Now, in Spain, the question remains to a large extent unanswered, although I will try to show that, in fact, the Constitution made quite transparent, a transparent option, if you will, chose quite transparently the moderating revising chamber model. So with that said, we need to address, however, a preliminary question, which is that I just gave you a heads up and said that I think that the Spanish Senate is more consistent with the model of a moderating or revising chamber. However, if one takes a look at the Spanish Constitution, in Article 69.1, the Constitution quite literally says that the Senate is the chamber of territorial representation, which might lead us to the conclusion that the model that the Constitution makes is that of the, shall we say, federal Senate. However, if one takes a closer look at the text of the Constitution, we may see that, in fact, there are very few, virtually no elements that make the Spanish Senate into a real territorial chamber. The Spanish Senate has no powers whatsoever regarding regional matters, or at least it has no powers on regional matters that differentiated from the lower chamber of the Spanish Parliament, that is the Congress of Deputies. It has no singularity, if you will, within the Spanish bicameral system that would make it a specialized territorial chamber. The Spanish Senate, for example, has no singular powers, no distinctive powers, as opposed to those of Congress. For example, in the approval or in the passing, sorry, or the modification of the statutes of autonomy. The statutes of autonomy are a form of organic law that basically create the different autonomous communities. These are the autonomous regions in Spain, or that create the autonomous communities, establish their institutions, and lay out their powers. Now, the statutes of autonomy, when they are passed by a joint work, if you will, of the Congress and the Senate, and in fact, it is the Congress that has the upper hand here. So no particular role for the Senate when it comes to statutes of autonomy. It doesn't even, the Senate even lacks any significant role in, shall we say, holding the government, the Spanish government accountable regarding territorial matters. So really, virtually no powers whatsoever on territorial or regional questions. There's just one exception, which is the coercive clause of Article 155. Article 155 is a provision in the Spanish Constitution that allows the Spanish government to impose certain measures directly upon an autonomous community when this autonomous community consistently has consistently violated the laws or the Constitution, or when it threatens the general interest. Now, of course, the Spanish government may not impose such coercive measures unilaterally. It requires the consent of Parliament, and in particular, and that is really the only distinctive territorial role of the Senate, it requires the consent of the Senate. When it comes to imposing coercive measures upon an autonomous community, it is only the Senate that may authorize the government to impose such measures. But of course, as you may realize by what I just said, the Senate, this coercive clause is not an ordinary measure. It only seeks to address very grave territorial crises that don't take place, in ordinary circumstances. And indeed, the only occasion in which Article 155 has been used was when the secessionist crisis took place in Catalonia in 2017. There have been no other instances of application of this article. If we focus, so far we have addressed the powers of the Senate. If we focus on the composition of the Senate, it isn't really reflective of this alleged territorial dimension of the Senate. Most senators are elected at the provincial level, and provinces in Spain have no political autonomy. They only have administrative autonomy. The territorial units with political autonomy, very significant political autonomy in fact, are the autonomous communities. And only about 22% of all senators are elected at the level of the autonomous community. Only about 22% of Spanish senators are appointed by the different regional parliaments, the regional legislative assemblies. So in fact, the Senate does not quite provide, if you will, a venue or a forum in which the autonomous communities may express their position at the decision-making process, at the national level. On top of that, even these senators that are elected that are appointed by regional parliaments, in fact, in the performance of their parliamentary duties, show no obvious differences with elected provincial senators. They vote along party lines. They don't seem to take a particularly distinctive interest on territorial matters. And in fact, in the past, it was very common that these appointed senators appointed by regional parliaments, were also at the same time members of the regional parliament. This is increasingly no longer the case. Very often, these appointed senators are not at the same time deputies in the regional parliaments. So they lack this sort of connection with autonomous institutions that might make the Senate more of a territorial chamber. So basically, anyway, to make a long story short, it really is the dynamic, the logic of political parties that dominates in the Spanish Senate, not the territorial, not territorial concerns, not territorial interests. Yes, well, I mean, I think I already said that. No need to delve into that any further. Okay, so we've just seen that the Senate in Spain is not really a territorial chamber. So what is it? My position is that the Spanish Senate is very much a moderating / revising chamber. Now, of course, as tends to be the case in other second chambers at the, in other countries, the Spanish Constitution establishes an imperfect form of bicameralism. The Congress of Deputies, the lower chamber, is far more powerful than the Senate. The Spanish difference might be that the Senate is uniquely, perhaps even, comparing it to other countries, is uniquely weak compared to the Congress. But basically, the Senate plays a second reading role. The Senate examines legislation that has been 5 minutes. Okay, splendid. Well, maybe not so splendid, but I'll do my best. Anyway, so basically, it acts as a second reading chamber that theoretically should introduce an element of moderation, of sober reflection in the bills sent by Congress. That is really not really the case for two reasons, basically. First of all, because the Senate actually is really weak when it comes to the legislative process. The Senate the Senate can veto legislation sent by Congress, but this veto can be lifted with the utmost ease by Congress, and very quickly, in fact. And the Senate may introduce amendments to bills sent by Congress but these amendments may be very comfortably, very easily discarded, rejected by Congress. Also, if we take a look at the Senate from the legislative standpoint, the Senate is a very, shall we say, passive legislator. It has very few, in fact, in the nearly 50 years since the Constitution was passed in 1978, only 15 bills, if memory serves me well, originating from the Senate, have become laws. So really a very weak legislator. And on top of that, the Senate, because of the very strong partisan grip, the very strong grip that political parties have over the Spanish political system, doesn't even have the autoritas, if you will, that, for example, the British House of Lords has. The British House of Lords is relatively weak compared to the House of Commons, but for several reasons that we shan't analyze now, it has certain autoritas that might make the House of Commons pause for a second and reflect when the House of Lords objects in some way or another to a bill from the House of Commons. That is not the case at all in Spain. I think I shall skip that, to be honest. Let me just focus on a recent development that might be interesting. So I just said that the Spanish Senate is mostly a weak second chamber. I need to add a caveat to that, which is that since 2023, the Senate has a different political majority than that of Congress. The Senate is under the control of the opposition. The main party of the opposition, the People's Party, a centre-right party, has a very comfortable overall majority in the Senate, whereas Congress is dominated by a relatively fragile majority that supported the investiture of Pedro Sánchez. And as a result of these divergent majorities, the Senate has become more assertive and is somehow emerging as a counterpower. It is issuing more it is opposing more vetoes to legislation sent by Congress. It has raised several conflicts of powers before the Constitutional Court against the government or against the Congress of Deputies. It has advanced bills that the government opposes, etc., etc. So basically the Senate is emerging as a counterpower. But the irony of it all, if you will, is that this increasing assertiveness of the Senate, these attempts by the Senate to use the very modest powers it has led to a diminution of the powers of the Senate. For example, I'll just give two examples, but I could offer a few more. In the old days, until not so long ago, when it came to approving the debt ceiling for public administrations, the Congress and the Senate had an equal power. If the Senate voted against the debt ceiling, then the debt ceiling was rejected. Now, this is not in the Constitution, this is established in ordinary legislation, and once the Senate, under opposition control, rejected the debt ceiling, the legislation was changed in order for Congress to be able to circumvent the Senate's opposition to the debt ceiling. Another example. When it comes to the appointment of the board of directors of the Spanish public TV and radio, the legislation was changed so that only 4 out of the 15 members of the board would be appointed by the Senate. And in fact, they would be appointed by an overall majority, not by the 2/3 majority that existed in the past, which means that if in the future the Senate and the Congress are in the hands of the same party, it means that we will have a board of directors controlled, whose members will be appointed by only the majority, with no minority members, which is a rather illiberal kind of move. Anyway, just time to reach the conclusions. So, as I said, the Senate is not a territorial chamber by any means, nor by its functions or its powers, nor by its composition. The Senate has just a revising, moderating role, but is politically very weak, and there are no ways, and it has no, shall we say, elements that compensate for this relatively weak constitutional position. The increasing assertiveness of the Senate is the result of a singular political correlation of forces, which may change in the future. So the Senate might become again a rather, shall we say, insignificant element in the Spanish political system. And in fact, the Senate's becoming more assertive, the Senate's introducing an element of discord to implementation of the will of the majority in Congress has actually led to the diminution of its powers. So in fact, once the Senate has become an obstacle, if you will, in opposing the will of the Democratic majority, this has led to the diminution of its powers. Anyway, I think I talked for way too long, so excuse me for my, I guess, for my endless chatter, and thank you for your attention.
Thank you very much. Not too long, 2 minutes. So it's all right. Yeah. Well, thank you very much for this very interesting panel. Also big panel. So my job now is to try to bring all this together, I think, and maybe ask you a few questions. So, well, first, thank you for these very interesting papers. When I first started to listen to the presentations, I had like the impression that there was a kind of common groundwork, so to say. Well, that's also what you said actually at the beginning. And this groundwork was a kind of opposition between populism and classic, what some of you called classic liberal constitutionalism. So like the idea that in constitutional law it would be possible to have a kind of clear-cut distinction between populism and classic liberal constitutionalism. But at the end of the panel, I think the picture you drew is a little bit more complex, and my questions will try to reflect that. Regarding the first paper, so you said that, of course, when it comes to populism in constitutional law, you cannot just go to a library and pick up a book and then you have the whole thing. But you mentioned that there is something in common in populist theory, and actually what you presented a kind of, a little bit, I would say, maybe idealistic understanding of populism. So there are populist thinkers who created this concept, and then it's being applied or it's being used by different political movements. I was wondering whether it really works like that, like in Spain, you have the example of Podemos, which tried to use this concept explicitly and apply it in politics. But I was wondering, for example, whether the Catalan independence movement tried to apply this concept and used, for example, Laclos and Mouffe. I'm not that sure. And let's say in France, we also have what is sometimes called a left-wing populist party, La France Insoumise, Unbowed France, which at first tried to apply these concepts and then just dropped them because they are more like pragmatic and strategic and not that much idealistic in their understanding of how they want to do politics. So it's not really like there is, kind of clearly defined populist thought, it seems to me at least. The second paper, also very interesting, thank you very much. You mentioned that the critics against the judiciary first appeared in the US and then arrived in Europe with contemporary populist movements like in Hungary and Poland. Well, there is also a country I know quite well where you can find this kind of discourses very early, namely France. This idea that judges have too much power, etc., it's actually a very old idea. Right at the beginning of the Fifth Republic, you already have this. So I was wondering, because, I mean, with regards to other aspects, you would say that French constitutional thought at that time also belongs to what you called classic liberal constitutionalism. But there's also this idea, this critique of a kind of juristocracy. So again, I think it shows that you don't have this kind of unity between, or clear-cut distinction between populism and classic liberal constitutionalism, but that you also have in this kind of classic constitutionalism what you would call maybe populist ideas. So it's already there. It's not like it appears at some point and tries to attack the other side. With regards to the third paper on Catalonia, thank you very much, also very interesting, because of course I understand this is a background of much of this work, this very problematic issue of Catalan independence. I was also wondering to what extent, because you've mentioned that the political leaders had or behaved like populists, have a populist reaction. But you also hinted that this reaction is actually, or has much to do with the role of established institutions, with the constitutional framework. So in other words, the Spanish constitutional framework seems to be to a great extent responsible for this reaction, which is also confirmed by the last paper regarding the Spanish Senate. Mm-hmm. So again, this is kind of example that populism is a reaction against what you might call classical constitutionalism and its failure to some extent. You also mentioned the British Constitution, and in the paper you write that the flexibility of this constitution enabled a solution to this problem. So this solution is not possible in the Spanish context because of the failure to some extent of the constitutional framework. So again, it means that there are different kinds of classical liberal constitutionalism. To some extent, some aspects might enable a solution to this problem, but the failure is also at the origin of the populist reaction. And the last papers, both papers actually, I think, confirm that by giving some examples of a different kind of liberal constitutionalism with Canada, which is to some extent similar to Scotland, it seems, in the functional role it plays, because it shows that there is within a different kind of classical constitutional tradition a solution to the problem, which is not present, which is not there in the Spanish context, for example, but which might be developed in other contexts. You mentioned that it's an example of liberal democracy being able to overcome the problematic of secession and referendums. Mm-hmm. So there is something there, which is not there in other contexts. And again, it goes against this idea that there would be a clear-cut distinction between populist constitutional thought and classical liberal constitutional thought, seems to me. So. And the last paper also, I think, confirms that, because it seems to me that what you wanted to argue is that the Spanish Senate might be an answer to the problem if this Senate would have or would play the role of a territorial chamber, but it cannot have this role because of some limits in the Spanish constitution and also in the political practice. So again, it shows that what is being called sometimes populism, like in the Catalan context maybe, is a reaction against some kind of failure of the established institutions. And in this case, it would be possible, I mean, it could work, but it doesn't work for some reason. And then it creates this kind of reaction. But whether you call this reaction really populist, I mean, it's hard to, I think it's a little bit harder to defend that, because it has, I mean, if populist constitutional thought is just a reaction to the failure of this classical constitutional thought, it's quite different to what Mouffe and Laclos were doing. So there's kind of, I mean, for me, it was quite interesting to see this transformation from a clear-cut distinction to something a little bit more differentiated and much more complex, actually. But again, thank you very much, and I think we can now open the floor if you want to give quick answers.
I start myself?
Yeah, please.
Yeah. Thank you very much for remaining here until the end. Yeah. Nobody's is leaving. Second, thank you very much also for the question to my chair. What I was trying to say is the following. At first, populism was created as a strategy, but was those against populism that made joint studies in order to know if there was something in common after the practice. And it's not the populist, but the adversary of populism that are ensembling the theory from the practice. And this is new. We don't have the theory and then the practice and then the opposition. We have this political theory that goes to the practice, and then the constitutional theorists, the traditional constitutional theorists, they are ensembling the populism constitutional theory that is way too liquid. And there is no one saying, oh, I'm going to try to create this populism constitutional theory. And this is something interesting. And it means that the people who were creating this has nothing to do with constitutional law. No one was thinking in a state way. They were thinking about power as a strategy. And thinking in that way, checks and balances has nothing to do in that theory. We have to remove these checks and balances because the main idea is the end, and the end is power. Both if you are in the opposition or in government. And also, who is doing this is Pierre Rosanvallon, who is creating from scratches this theory against the populism is Pierre Rosanvallon. And also, maybe they are not saying in the Catalan movement directly the things that Laclau or Mauve they are saying, but they are acting with the steps that we have put. Just we are creating the enemy is an agonistic enemy, and we have to have all the institutional power in order to create and recreate the hegemony, and not let them to win the power, but without taking out the electoral system or the vote. And I think that maybe Podemos is one thing, that they went there, they talked with Ernesto Laclau, they were creating this idea with them, and the other ones was just recreating the ideas, but without the theoretical foundations there. I don't know if I answered, well, more or less.
Yeah. I don't know if you want to, or we can also open the floor.
Yeah, we can try to reply. Who wants to answer?
I'll try to be as brief as possible, even though the question is rather complicated. Of course, there are different versions of liberal democracy, different traditions. The French tradition is a very important one. And of course, in the French tradition, there is this element of Jacobin democracy. It's playing a very significant role in shaping the role of the judiciary in France. And it's not easy to distinguish between Jacobin democracy and populism, no? As long as both advocate for unlimited democracy, no limits on the powers of people. Then it is also true that in Europe, those different versions exist in German, French, Italian, are more and more uniformed by the role of the European Union and the European Court of Human Rights. If you look at the roles of advocates before the Council of State in France, the same evolution of the Constitutional Council, all these elements clearly show that there is a tendency towards a model of European constitutional democracy, like our project is titled. So, yes, but those different versions are pointing, at least within the perimeter of the European Union, I think, in the same direction. So I stop here so that I leave some space for.
Okay. Thank you very much for the question. I think it's you have raised an excellent point, and I should probably have I should address that in the presentation. So the thing is the lack of flexibility of the Spanish constitutional legal order to be blamed for the populist reaction? Okay, several things. First, I think that there are good reasons from a democratic approach to oppose the organization of a referendum on secession in liberal democracies. The idea that referendums on secession are about democracy, I think, is a bit misleading, because the organization of a referendum of this kind is at first not so much about democracy, but it's about pre-democratic criteria of deciding who belongs to that people that is going to be entitled to vote. And these criteria have to do with language, history, culture, race. They have to do, these criteria, with nationalism, not with democracy. Once you have established that that group is a nation and is entitled to vote, then you decide how they are going to make a decision. And then comes into the equation democracy, because you assume that the best way to move forward is through a democratic instrument like a referendum. But the first decisions have to deal with something that has nothing to do with democracy, but with nationalism. Why is more democratic that only Catalans decide and not all Spaniards decide? Because the decision is also going to affect the citizenship rights of the rest of Spaniards. So in purely democratic terms, I don't think that there is a good reason why the smaller group should be the one deciding, in purely democratic terms. If we assume a different type of approach, a nationalist approach, then of course we might reach a different conclusion. But what I'm trying to say is that it's a bit misleading to say that is a democratic issue. Then the second thing is, even if I believe that there are good reasons to oppose the organization of a referendum, and even if, as a lawyer, I believe that law, in fact, is not so much about delivering justice, but about offering a framework that guarantees a peaceful coexistence. So I think that there are also good reasons to obey a constitutional, a democratic constitution. Even if I believe that, I also believe that there is honestly no constitution that will prevent any region within an EU member state to become independent if there is really a clear majority behind that movement. I mean, do we really believe that if in Catalonia there was an effectively clear majority of people in favor of independence, the constitution or the Spanish legal framework would be a real obstacle? I honestly, and I'm a lawyer, I honestly don't buy that. And the elites in Spain are also very aware of that. If there was constantly over time a clear majority of Catalans demanding independence, there is no constitution that is going to oppose forever that. So the reason, I think, behind the populist reaction is not so much the constitutional framework. The constitutional framework is not as powerful, I think, but is the lack of will among Catalan politicians to admit the pluralistic composition of the Catalan society. Hugely divided when it comes to this issue. There has never been a clear majority in favor of independence. And also because, I mean, I skipped that part, how the not the populist, but how the pro-independence movement started to grow in Catalonia. I skipped that part, but maybe that was also an important part of the presentation. The pro-independence movement really started or really gained traction in Catalonia in 2012, when in the middle of a huge financial crisis in Spain, we were on the verge of being economically collapsed. We were almost about to be intervened by the EU institutions. And the Catalan government, the regional Catalan government, was one of the regional governments introducing the most acute social expenditure cuts in the Catalan budget. Health and education were severely affected in Catalonia because of the cuts of the regional Catalan parliament. People were protesting before the Catalan parliament in a way that forced the president of Catalonia to escape the Catalan parliament with an helicopter. The process had not started yet. The leader of the Catalan government at the time then went to Madrid, to the central government, and said, look, we, the Catalans, we pay too much taxes to Madrid. We are offering too much money to the rest of the country. We need to revisit the financial agreement. We need more money for Catalonia, basically. I'm simplifying a bit. And the response of the former prime minister well, not prime minister technically, but the leader of the Spanish government at the time was, well, we are on the verge of being intervened by the EU institutions. We cannot do that at the moment. There is a huge financial crisis. This is not politically or economically possible. And it was then that the Catalan government said, okay, the way out is independence. So populism, I mean, I'm not trying to defend the position of the Spanish central government. I think that there were lots of mistakes that were done that have been done by the different Spanish governments. But the populist reaction was very much a Catalan one, not so much a reaction of either the constitutional framework or the Spanish government. I think that most of the responsibility lies within Catalan leaders. That's my point.
Try to respond to your question. Thank you very much for making the effort of making so many questions and try to raise the different topics that have been analyzed here. The contrast between Canada and the United Kingdom on the one hand and Spain is very strong, apparently. But I don't think this is the most important thing here, because the opinion given by the Supreme Court of Canada goes far beyond that, goes far beyond the fact of allowing a secession referendum. This is, as I tried to argue before, this is not the most relevant aspect of the opinion, because for the Supreme Court, the referendum was possible. It was possible according to Canadian constitutional law. That was not something that was debated. That was not something that was argued. The Spanish situation is completely different, because constitutional law does not allow that referendum. Given this, I mean, if we start with these two differences, then we can see the interest also for Spain of this opinion given by the court in 1998. The court, first of all, accepts the problem that exists in heterogeneous states, that is, states that have permanent minorities. And this is something that is also interesting for Spain, of course. But the court gives a solution that raises in turn many, many other questions, because what the court says is that the answer has to be procedural. The answer is at the procedure that we design in order to make this sort of decision that is so controversial. And it sets up certain principles, constitutional principles, that have to structure that procedure. And this is something that is, of course, of fundamental interest in Spain when trying to deal not only with secession, because secession is the response to secession is limited by the constitutional framework, but when trying to articulate decisions concerning, I don't know, finances, for instance, in the different regions in Spain, etc., etc. How can these reflections be used in a country that has a different constitutional framework, but that also has these problems when having to make a decision that affects everyone, but maybe affects particularly certain groups that are always going to be a minority? And this is something that is at the core of the opinion given by the Supreme Court. And the Supreme Court says democracy is very important, but democracy is not the only thing that we are going to take into account. Majority rule, I mean.
Yeah.
I'm not sure if I remember any more the question you initially asked. To be honest,
that was like about the possible institutional solution to the problem, but it's actually not working in Spain for different reasons, I think.
So, I mean, I'm very skeptical about the turning the Senate into an actual territorial chamber as such. I'm very skeptical about it because the nationalities within Spain that, shall we say, have a stronger desire for self-government, the Basque Country and Catalonia basically, are not particularly interested in using the Senate as a forum either to express their views. Usually they tend to prefer to have a bilateral relation with the Spanish government as opposed to, you know, to sharing their views in the Senate along with other regions that have, first of all, shall we say, a more shallow desire for self-government and less distinctive identity and sometimes a virtually non-existent tradition of self-government and or of autonomy. So I think that the Spanish Senate might be helpful if it actually became a functional moderating chamber. And that is very difficult, not just because the Senate's powers are so weak, but also because the Spanish politics is just dominated to a fault, really, far excessively by party discipline. It is virtually impossible for a legislator in Spain to cast a vote against the will of the party leadership, which might sound surprising, I guess, to I don't know, to a Frenchman or to a British.
Not at all.
Well,
Not at all.
not at all. But I mean, in France, at least now and then, you see legislators voting against the party leadership. In Britain, it's systematic. In the United States, it used to be systematic, maybe not so much anymore. So I think that makes it very difficult for the Senate to have credibility, because in order to, if you are the weaker second chamber and you have actually, well, relatively weak powers, you need to have at least some kind of authority or some kind of distinctive element to make up for your weak constitutional position. And this element is simply lacking. So either we increase the powers of the Senate or the senators start taking their job as, you know, as elder statesmen, if you will, more seriously, or we aren't going anywhere. And if on top of that, the government undermines the Senate in every occasion that the Senate acts as a counterpower, in depicting it as some kind of like obstructor, is that even a word in English? Obstructor of the democratic will of the people representing Congress, then quite frankly, we are quite undone. So that would be my answer.
Thank you very much. My apologies for asking too many questions, but please feel free now to ask questions if you have any. I think we still have some time, right? Like 5 minutes. Yeah, it was a long panel, so we need a little bit more time for discussion. Yeah, please go ahead. Yeah.
Wrap them all together.
Right.
Or maybe we can ask several questions and then wrap them all together. Yeah, yeah. So
just a bit of academic nitpicking. The calls in Hungary did not start with the judiciary, did not start with Orban. They've been ongoing since 1989. Because at the end of communism, the constitution instituted a very strong judiciary. And because they were the first to transition, the Communist Party negotiated, and they had half of them members of the Supreme Court. So what the Supreme Court was, the Constitutional Supreme Court was trying to block privatization, it was blocking transitional justice. And these quarrels have been going on for 20 years. Similar thing in Poland. A bit less so in the Czech Republic, because there the negotiation position of the communists was weaker. So the judiciary, at least in the Constitutional Court, was non-communist. So that's really, and that's why people there don't really feel the change, because it's just, there's a continuous quarrel, and the judges are always incompetent and are always politicized. Just they used to be communists or now they're nationalists. Not much change. And then a really scary question. Heidegger. So Dasein, I mean, it's concrete in the sense that it is fallen into the world. But the properties of Dasein, they're not particular to a particular space and time or a culture, even though, of course, somebody like Marcuse accused Heidegger that this was the proto-Nazi character, the fallenness, the anxiety, and so on. But that doesn't have any of the cultural specificities that the populist seems to be working with.
Yeah, go ahead.
Yeah, thank you so much. I have also like a question or like a comment on the more theoretical part actually. So for me, it was just not like completely clear, I guess, which parts of the work you're actually referring to, because it's sometimes the impression you're like drawing mainly on the early part, on like their collaboration, hegemony, and social strategy, no? And I was wondering why you not were like engaging the later work, where they developed the theory of populism, like on populist reason, for example, by Laclau. And also, when like engaging with this later work, I'm wondering where like Carl Schmitt is like appearing or not appearing, because I had the impression that like for this whole question of agonism and the paradox and so on, the work of Carl Schmitt is like super crucial for MOVE. And this might also change a bit how one thinks about all these different like ideas of populism. And the other thing is that I believe when you derive this constitutional theory,
sorry, I'm really embarrassed, but I did not understand the main idea. So if you can do it like I'm a little bit dummy.